The next topic in the Bill of Rights is something we call due process. Due process is actually scattered around several amendments in the Bill of Rights: the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, and the Eighth Amendment. And putting them all in one video would probably just make it too long. So we're going to chop it up and do one amendment at a time. This video is devoted to the Fourth Amendment. Make sure that you watch the next three videos on the Fifth Amendment, the Sixth Amendment, and the Eighth Amendment to get your full dose of information about what we call due process. And when you get to those other videos, you can probably skip the next 4 slides in those videos, 4 or 5 slides, as long as you pay attention to that information in this video. It might be helpful to have a copy of the Bill of Rights with you. It might be helpful to have this 23-page packet full of Supreme Court case summaries that you've been provided with. It might be helpful to you to have this one-pager that you've been provided with that lays out the entire concept of due process from beginning to end. It's really good to have that understanding of due process, so you don't just focus on the words due process that happen to be in the Fifth Amendment, and you understand that the concept of due process is scattered across several amendments and other places in the Constitution, and isn't just associated with the trial, but also concepts before and after the trial. And it would also be helpful to have this page of due process related Supreme Court case decisions that you've also been provided with. The phrase due process refers to all of the rights that are due to you. That means you get them. The government is required to respect these rights that are necessary for you during any sort of government process that affects you. Any sort of process means procedures or steps that the government takes when it makes decisions about you. And usually when you're talking about due process, you're talking about the legal or the criminal process. The government is deciding whether or not to lock you up or punish you in some way. So maybe one way to summarize due process is all of the necessary steps that government must take in order to punish someone, or in other words, all of the rights you must receive in order to have a fair trial. For this reason, sometimes your due process rights will also be referred to as the rights of the accused. And as the chart that you've been given tries to illustrate, your rights as an accused person, your rights as a citizen, your due process rights begin well before a trial. They exist before the trial, they exist during the trial, and after the trial. They are referred to in several places in the Constitution and by several amendments in several places in the Bill of Rights. For example, if you refer to the due process rights and related cases handouts you've been given, you'll see that your due process rights restrict the behavior of the government even before you are arrested, because in order to arrest you, the government must have something called probable cause. Probable cause based on evidence it has already gathered. The gathering of that evidence is pretty much the rules for gathering evidence are laid out in the Fourth Amendment, where it says you have freedom from an unreasonable search and seizure. So the government must conduct its searches or seizures of property or evidence in a legal manner consistent with the Fourth Amendment. Those cases off to the right there, don't worry about those. We'll discuss those later in the video. Your due process rights are also in effect after you've been arrested or taken into custody and before your trial begins. For example, in the Constitution itself, it says the government cannot arbitrarily detain you or indefinitely detain you without any specific charge. That's called your privilege of the writ of habeas corpus, and that's in the Constitution itself, Article 1, Section 9. The Fifth Amendment, the Sixth Amendment, the Eighth Amendment all have something to say about your rights and the limitations on the government's power in between being taken into custody and having your trial. Notice a couple cases over there on the right. We'll talk about those in later videos. During your trial, you have additional due process protections. Most of them are found in the Sixth Amendment. You can read them over here or on your handout. But there's a little bit of the Fourth Amendment protecting you during the trial, and a little bit of the Fifth Amendment protecting you during the trial as well. The only case in this video that appears over on the right is Matt versus Ohio. It is not required by the College Board. However, the concept that's associated with Matt versus Ohio, the exclusionary rule, is an important concept, frequently appears on AP exams, and will be discussed in this video. After your trial, your due process rights continue to protect you from government misbehavior, let's say. Most of it is covered by the Eighth Amendment. There's still a little bit of Fifth Amendment protecting you there too. There are a couple cases there mentioned that'll come up in the Eighth Amendment video. And then just to make sure you get a complete picture of the idea of due process, there are things in the Constitution and in the Fifth Amendment that govern government behavior kind of completely outside the legal system. We call those extrajudicial prohibitions. You've already learned that the government cannot just pass a law declaring you to be guilty. That's a bill of attainder. The government cannot pass a law that says what you've done that was legal in the past is now illegal and you can be punished for. And then there's another little bit of the Fifth Amendment that is helpful also. So as you can see, different amendments kick in at different points in the process. The concept of due process is scattered all over the Constitution and the Bill of Rights. So now let's get on with the rest of the video.
The right of the people to be secure in their persons, houses, papers, effects, against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized.
The key concept in the Fourth Amendment is the concept of an unreasonable search and seizure. Basically, there are rules governing when it is legal and when it is not legal for the government to invade your privacy and search your person or your belongings and gather evidence and seize them from you. The concept of a warrant is a piece of paper issued by a judge. He can't just do it because some cop drops by and says, hey, let's go search something in this guy's house. It has to be based on evidence already gathered, strongly suggesting that more evidence will be found. That's called probable cause, that if they search someplace, they'll find more evidence. Warrant has to be signed by a judge and sworn as true by a police officer. Swearing to God that something is true is called an oath. Swearing on your own personal honesty and your own word, that's an affirmation. Either one is good for a warrant. A warrant has to be fairly specific. It has to describe more or less specifically where a search is going to take place. And it has to describe what's being looked for, the person or things to be seized as evidence. This was specifically worded this way because when we were ruled by the British, something called a general warrant was a common occurrence. A general warrant under the British system meant that the authorities could search anywhere they wanted for anything they wanted, for any evidence they might come in handy to prove you're a criminal. So that's why Madison specifically worded it this way when he wrote the Fourth Amendment. General warrants not allowed. Our warrants have to be fairly specific in where and what is being looked for. But if you looked, like we've said about the Constitution in a lot of situations, this sounds specific, but if you really analyze and look closely at the words, it's all pretty vague. Life is very complicated, and there's lots and lots and lots of issues to resolve here, so let's get to it. The first case I want to discuss here is from 1914, Weeks versus U.S. This is important not because the College Board has said this case is necessary or required. It's not. But it is interesting because it's the first time the Supreme Court enunciated something called the Exclusionary Rule. This is a federal case. Notice the U.S. as a party. So I guess it was the FBI. If the FBI even existed then, I don't even know. But anyway, federal agents gathered evidence against somebody, and the Supreme Court later decided that the way they did it broke the rules in the Fourth Amendment. And they faced the decision of, well, how do you deal with this situation? How do you punish, there's at least a couple ways. How do you punish the government for breaking the rules? There's at least a couple ways to do this, and one of them could be, then the actual individuals, the cops or the FBI agents or whoever, maybe they could be personally punished, but the evidence that they gathered illegally, that could still be used as evidence in a court proceeding or trial. Another way to punish it would be to say, well, anytime anybody ever breaks the Fourth Amendment in the gathering of evidence, then that evidence cannot be used at trial. The Supreme Court used that method of punishment. It's called the exclusionary rule because any evidence that is illegally gathered by the government is excluded from the trial. It can't be used in a trial. It can't be shown to the jury. The jury can't be told about it. This is important because eventually this rule, the exclusionary rule, will be applied to state governments as well. This was a federal trial, so at first the exclusionary rule only applied to the federal government, but eventually it does get incorporated, and I think we'll see that on the next slide. The next case kind of interesting here because it brings up an interesting issue. The Hester case from 1924. The police went on to someone's private property and gathered evidence. The Supreme Court said that this was okay. The Fourth Amendment mentions your person, your house, your papers, your effects. It doesn't mention the space around your house. And the Supreme Court has faced this question over and over again. At what point is your house your house? Is your yard your house? Is the garage your house? Is, a field next to your house, if you own it, whatever. Anyway, in this case, the Supreme Court said, even though it was the property of the homeowner, it was a field and it was open enough and kind of, in a sense, public, easily visible from off the property. So the Supreme Court said that gathering evidence from the field was constitutional. That's called the open fields doctrine. You don't have to know that, but you do have to know about the issue of sort of location becomes really important here. The most private area you have is your home. But as you get outside your home, you're going to have less and less of an expectation in your mind of having privacy from the rest of the world, being private from the rest of the world. And you'll see that as we go through other cases, the Supreme Court has said gradually you lose some of your protection from the Fourth Amendment the farther you get away from your home. Speaking of which, in 1948, the Johnson case, there was another federal case. She was arrested in her hotel room, and the Supreme Court later said that was unconstitutional. She was living there, not just staying there temporarily. She was actually living there. So in a sense, that was her home, and she got full protection of the Fourth Amendment, and the search that was conducted and the evidence that was found was all invalid. In 1961, Mapp versus Ohio. This is an important case. It is not a required case by the College Board. However, since this is the case in which the Supreme Court incorporated the Fourth Amendment and the exclusionary rule and applied it to state governments, notice Ohio is one of the parties in this case. You don't have to know the facts of the case. You don't have to know it by detail, but you do have to know that the exclusionary rule that was first enunciated back in 1914, I think, and applied to the federal government was eventually incorporated and applied to state governments in a case called Mapp versus Ohio. I can't emphasize enough, the exclusionary rule appears on AP exams over and over again. It's fair game on the current format, and you should make sure you understand the exclusionary rule. Given that I've mentioned how important the exclusionary rule is, you should probably also be aware that there are some exceptions to it. These two cases, both from 1984, one was a state legal system and one was the federal case, they established the possibility that, there's this exclusionary rule if the cops or the FBI don't follow the rules laid out in the Fourth Amendment, then any evidence they find can't be used at trial, is excluded from trial. These cases are interesting because these bring up important exceptions called good faith exceptions. And basically, to summarize both cases, there were flaws with the warrants. The warrants that were, signed by judges, whatever, there were technical problems with them. I think one was a clerical error, meaning the paperwork was wrong. It didn't say exactly what it needed to say. The other one, I think the judge made a mistake. I'm not really sure what it was. But anyway, in any case, the policeman executing the warrant, conducting the search with the warrant, believed that the warrant was valid, was unaware of the mistakes. And the Supreme Court said in 1984 that that's okay. Minor errors, minor mistakes on a warrant, if they're in good faith, meaning they're honest mistakes. No one, plotted to do this. No one planned it. Just because there's a technical problem with a warrant doesn't mean the exclusionary rule always applies. And in some cases, the evidence can be used. And just because there's a problem with a warrant doesn't mean it's automatically excluded. Those are called good faith exceptions. The next three cases are all about schools. A couple slides ago, we talked about how you get less and less of an expectation of private or privacy from the government the further away you get from your home. Well, here's the scoop, folks. At school, especially since you are minors, you do not get anywhere near the full protection of the Fourth Amendment. In the 1985 New Jersey versus TLO case, this is summarized in that packet of cases I've given you. A young woman in high school, I believe, was caught smoking. She said she hadn't been, but someone had seen her. So based on that lie, a school official felt he had a reason to search the contents of her purse to find out if there were cigarettes or whatever. And he found out a whole bunch of stuff that was basically criminal in nature. And she was punished. The question in the case is, was the search of her purse constitutional? The Supreme Court said, well, there was no warrant, but since she's a minor and since she's in school, and she might possess something that she could use to hurt herself or hurt someone else, and safety is really important in schools, the Supreme Court said that school officials do not need a warrant based on probable cause. They only need a reason, some founded suspicion, some evidence of some sort that's good enough for a principal or a vice principal or a security officer to conduct a search. So that's constitutional. Now, in the state of Maryland, a teacher can't conduct a search, but I can say I think something's in somebody's backpack, and a security officer can conduct the search. Anyway, basically the bottom line here is that you do not get the full protection of the Fourth Amendment in a school because you're a minor and you're not at home, and it's our job to protect you from stuff. 10 years later in Vernonia, a different school system, I believe out in Oregon, came up with a policy. There was a drug problem on one of the sports teams, a football team, I believe, and they instituted a rule that says if you want to play sports, you have to agree ahead of time to random drug testing. Now, a drug test is a search. It's a search of your body. So this was a fundamental constitutional issue that made its way to the Supreme Court, and the Supreme Court said, well, that's okay. Playing football is not a right. It's a privilege. The school system has an interest in making sure that students aren't doing drugs. You could hurt yourself playing sports and being on drugs. You could hurt somebody else. So it was a valid thing to do for a school system to have that policy. A few years later, a different school system, I think this one is Potawatomi, Oklahoma, I think, said that, well, okay, we're going to have random drug tests required for any school activity, any after-school activity, choir class, or chess club, whatever. Not that it's a wise use of money. It's just that if they want to have that policy, the Supreme Court said that's okay, based on the same reasons as the other two previous cases. These three cases are about just sort of being out of your house and walking around or driving around. 1968, Terry versus Ohio. This led to things called Terry stops. Basically, it is legal for cops to just sort of walk up to you on the street and excuse me, and to say, hey, we just saw you talking to that guy, or we saw you do something kind of looking suspicious, so we're going to search you right here on the spot. The Supreme Court said that was okay, based on reasonable suspicion, out in the world, not in your house. If you've done something that is suspicious and it's something that is describable and definite that a cop could later describe in court to a jury, not just you kind of look shady, but you've done something, or there's something about you that led them to believe that you might be involved in a crime, that you can be stopped and frisked in public, searched without a warrant. 1983 Neville case, basically, you're in a car, you're driving, you've done something to make it look like there's suspicion of drunk driving, and if you refuse a breathalyzer test, a state was first, in this case, given the permission to assume to treat that as evidence of guilt. The refusal of a breathalyzer test as evidence of guilt, that is legal for a state to do. And in the 2002 case was basically sort of an updating of the Terry case from 1968. If there's something about your driving that makes you that it is suspicious, and the total of your actions is of your observable actions are lead a law enforcement officer to believe there's something illegal happening in your vehicle, you can be pulled over, and a search can be conducted based on just the outside observations. Here are some more modern cases you might think are interesting. In 2004, a man named Heibel, I think this is in Nevada, I'm not sure. I think his car was disabled, by the side of the road, and cops were looking into some crime that had just been committed someplace, and they saw him by the side of the road, and they drove up and they said, "Hey, what's your name?" And he didn't want to tell them. And that turned, believe it or not, that turned into a Supreme Court case. And the Supreme Court said, well, yep, the police have a right to know your name. You cannot legally refuse to tell police officers who you are if they ask. So there you go. 2014, Riley versus California. This is another traffic stop case. Basically, were the police permitted to search your cell phone after pulling you over and arresting you? And the Supreme Court said no. They can search your car, they can search your person, but because a cell phone contains so much more information about you, and there's nothing on a cell phone that could be dangerous to a police officer on the spot, it was decided by the Supreme Court in 2014 that in general, the police need a warrant to search your cell phone after they arrest you. And in 2018, this was a very recent case, the Supreme Court said that the information that is gathered about you by your cell phone provider, you may not know this, but your cell phone is constantly telling all the cell towers in your area, here you are, here every few seconds it checks in with them, and that data is recorded by Verizon or whoever, and that can be used to track your location. The Supreme Court said that in this case it was federal authorities had used cell tower records to locate where a suspect had been over the last few days, and it was determined that he was in the area of a bank robbery or something, using cell tower records that they did not have a warrant to search. The Supreme Court said, got to have a warrant. So I hope you found these cases to be interesting. They are only a very small fraction of the total number of cases the Supreme Court has been asked to decide over the years involving Fourth Amendment issues. The things you have to take away from this video are the Fourth Amendment is about search and seizure. It comes up a lot. And you have to know the exclusionary rule, the fact that if authorities do not follow the rules in the Fourth Amendment, then any evidence that they do find and seize cannot be used in court, is excluded from court. However, there are good faith exceptions to it. Technical problems with the warrant will not necessarily kick in the exclusionary rule. And then also just these issues, these Fourth Amendment search and seizure issues come up all the time. You have the greatest expectation of privacy in your home. You lose that privacy as you get further out into other areas of life, at school or in your car or whatever. And cell phones have been coming up in Supreme Court cases at least a couple times in recent years. And finally, make sure you catch the next video, which will be devoted to the Fifth Amendment.